seller has a choice and how they're going to ask that listing agent to market their property. It's not going to be something that is marketed in Bright. It's going to be something that you can advertise as part of the listing. Okay, so in your preferred terms or in your sheets or something that you want to put at the listing in order to bring in more offers, you can certainly have it there. That's where that will be. Okay, and it says
You can put that in your terms,
It-
that get posted on Bright.
no. I said it's not going to appear in Bright, but it can be something that you offer.
Somebody asks,
Exactly.
how do you want your offer written?
Exactly, or if you have a term sheet like that, that's information that you can provide as it relates to it. Okay?
But it can't be in view documents.
So it can't be in view
Yes.
documents, exactly. And you know, this is a little bit weird in that Bright isn't doing this until August. And we're kind of doing this now in order to get out in front of it. I mean, we do our updates in January, we do our updates in July. So we want to have everybody familiar with it. You're going to still have co-op compensation going on until August 14th as it relates to that. So I just want you to just keep in mind, we're about a month and a half ahead of ourselves, okay?
So no view, yeah, go ahead. Go ahead.
The listing broker owner, if there's no co-op fee, can he force that listing broker to put it in Bright?
There's
Legally, if there's no co-op, I mean, why put it in there, you know, if the selling agent, wants it can pay, so.
Can the listing broker I'm sorry, I didn't understand the question.
All right, yeah, the listing broker owner,
Yes,
he's gonna pay him 3% or 6% or whatever, but he's not gonna, and he doesn't wanna pay a co-op fee, does he still have to put that in Bright? Do you know?
that he's not paying a co-op fee.
Right.
As far as, I'm not an expert in what Bright's rules and regulations are, but I would say if he's not going to offer a co-op fee, then he's not going to put it in Bright as it relates to a co-op.
So what's really gonna happen with Bright now is, as of August 14th, the entire compensation discussion in Bright is gone. Unless, and the only part of the compensation discussion that's going to be present, the only kind of money issues that are going to be present are what kinds of seller concessions are going to be put in there. And compensation is not going to be one of those. So it's going to simply be the seller is offering concessions for XYZ, whatever, but it's not going to be broken out in terms of how much the seller is going to offer in Bright. It's not going to say that. It can't be in the remarks, it can't be in the view documents, and there will no longer be a field. So the field that we see today for buyer agency compensation and sub-agency compensation is gone as of August 14th.
That's right.
Yeah.
Can I ask?
Oh, go ahead.
Oh, no, you go ahead.
Go ahead, Darian.
Hey, good morning.
I was on the, this is Mel. I was on the Bright webinar yesterday, and they said that you can put in the concessions field that seller will offer 3% concessions.
No, yes, in sections, yes, but it doesn't break it out that that's going to be for compensation. Concession can be buyer closing costs. It can be any of the normal kinds of concessions that we have. But the only place that you're going to be able to insert compensation is after the deal is done. Then when the deal closes, then you can go ahead and say there was a buyer brokerage compensation of X%. Then you can do that. But that's only going to appear after the settlement. Before settlement, there will be no reference at all to compensation, to the seller's compensation for buyer brokerage fees.
Well, and just Mel, I'm glad you brought that up because that's why we define further seller subsidy and what that means. Because we've had seller subsidy in our contract. It's at the bottom of page 1 where we're kind of going through the analysis. And now we've added an additional provision in there regarding seller paid buyer broker compensation. So certainly the seller could offer a seller subsidy of 3%. And that can be applied however the buyer wants it to be applied. It could go to, in my example that I just mentioned, it could have gone to exactly what happened in this deal that just got ratified, which was it paid the buyer brokers, compensation, if you will, okay?
Mhm.
Yes,
It could be done after settlement, well, that's gonna go on the settlement sheet, doesn't it?
Yes.
Legally?
Yeah.
It'll be on the settlement sheet.
Means
Well, how,
bright.
pardon?
He means it would be in bright after settlement,
yes.
not.
Oh, that's right.
Yeah, and right,
It's in Bright after settlement so that, because Bright wants that data as it relates ultimately to the value of properties and things like that.
and they want that because of the appraisers want that information. So if they're going to look at your 123 Main Street that just closed, they would like to see that there was a buyer brokerage compensation in those numbers so that they can adjust for that if they need to in their appraisals.
So we have two things going on. We have NVAR, which we're trying to get through, and then we have Bright.
Exactly.
So you gotta make sure that we know that, maybe we'll just stay on NVAR for now.
Yep,
Let's go with the
That's
Bright.
exactly true. And we've been talking, and those of you on the call, we've been putting out a lot of material on the Bright side of things already. So we have Kathy's got a good point. Let's stick to the NVAR portion of this and not get sidetracked into the Bright so much, because we are discussing that in other forums. And if you haven't caught those up, please look at your emails, because we've been sending that material out quite consistently.
And so I'll just mention this. So paragraph 6, we're talking listing broker compensation. Paragraph 7, we're talking about seller paid buyer brokers compensation. 8, okay, paragraph 8 is seller subsidy as it relates to that. And so there's a point for each and every one that takes us through page 2 of the handout. And then at the top of page 3 has the seller subsidy provision, okay?
So why do you need both? Aren't 7 and 8 the same thing?
The reason why, the 8 could be used to pay for 7, but we wanted to give both options as it relates to the listing, because we may have situations where look, if and when we switch to a buyer's market, a seller may want to offer to pay, obviously, the buyer broker's commission, and they may want to, on top of that, have a seller subsidy in order to entice as many offers as possible on their property. So we're trying to think this forward and breaking it out based on that. But seller subsidy, paragraph 8, could be used any way that the buyer would want it to be used.
So if the intention of the seller is to pay a 3% buyer broker compensation, you only want to put it in one of these two places, not in both, in the listing agreement.
That would be right, exactly. And ultimately, compensation as it relates to a subsidy, compensation as it relates to the buyer broker's fee is going to be determined on the contract itself. So the fact that the seller has agreed to these things in the listing agreement doesn't mean that it doesn't transfer over. The seller's going to get offers, and then they evaluate those offers as it relates to that. Does that make sense?
Yeah,
Okay.
we used to have the Bright MLS publishing of the compensation, holding our seller's feet to the fire. What if our seller says, yeah, I'll give 3%, and then you finally get a contract 3 weeks later, and they're like, this took so long, I only want to give them 2%. Does this contract hold them to 3%, or can they change it when they're negotiating the contract?
The contract is completely negotiable between what the buyer pays and what the seller pays as it relates to this. But you have a binding agreement regarding the seller. Your listing agreement is a contract between, Remax Distinctive and ultimately the seller, and they're supposed to honor the terms and conditions of that
On
contract.
our commission?
Yes,
Listing agent?
Yes,
Do
but-
they have to honor the buyer broker?
they're not,
Seven?
this is the way that I would look at it. They have a duty to act in good faith, under all of our agency laws. If they ultimately had agreed that this is what they want to pay, then they should, if they get the price that they're looking for and things like that, then that should be an agreement that they honor, okay, as it relates to that. It would be for them to agree to this, you market the property, do all your due diligence, and they're like, you got exactly what I was looking for, but now I'm changing the game. Well, that would impact the offer, which ultimately would impact your ability to make that commission. So when you're having a conversation with the seller, say you're relying on this information, just like you're relying on the fact that the debts that they have are correct, that they actually are the owners of record and things like that, right? All of those things are representations and warranties that that seller is making that you, as the listing broker agent, are relying on in order to get them the best price, okay? But when it comes to, so what we reference, and I'm going to get to this in just a second, there's a new paragraph regarding broker compensation that irrevocably instructs the escrow agent, you know, the settlement agent normally, to actually pay the commissions that ultimately are due as it relates to these agreements. All right, so
Wait a second, we collect our commissions from the settlement company?
the- well,
That was really confusing to me. I'm sorry to interrupt like that.
no,
you're-
it's not corruption at all. I mean, the settlement company actually pays the commissions and it's right there on the Alta now.
Well, yeah.
There's no, as it relates to that.
Are you saying we would actually pick up our check at? I'm just trying to understand all this because it's a totally different universe than what I've been used to, but would we be picking up our checks at a settlement company instead of our brokerage office?
No, well, how you're.
Sorry, that was a juvenile question. I know, but
Not at all. And every group's a little bit different in the way that we pay, the settlement company pays the broker. And that commission is on, and by we, I mean all the settlement companies that are out there. And then ultimately, we pay the broker, and however you get your portion of the commission from Remax Distinctive, that's between you and your broker.
Yeah, your payment is still gonna come from Remax Distinctive, just the way it's always come. It's just, and so nothing changes. Nothing changes as far as that's concerned. It's really the title company is gonna be paying our brokerage then cuts the check or the ACH to you, depending on your split and whatever that is.
Yeah.
okay. But in asking for it on paper, on the offer, it either goes in other terms or it goes in the seller subsidy line if you're trying to go that route.
It doesn't go in other terms. You know, in the example that I gave you before, we needed to do an addendum to the contract because there wasn't
Straight
any
addendum.
when a co-op commission was not offered. In this case, it's going to be right on page 1 of the NDAR contract.
Okay.
Front. Okay.
Okay. May I also ask, does it feel like we're in the 70s or 80s where everybody works for the seller again?
You've made a lot of people have felt the same way, you know, this idea of sub-agency and everyone's working for the sellers. I think what's really important, and we're in a unique market in that all 3 jurisdictions, and I know not everyone here works in all 3, but the brokerage does. So I'll just speak to that. We have had buyer agency agreements, I think, since 1999. Where this court case was decided, they didn't have buyer agency. And in many parts of the country, they don't have buyer agency. So they are way behind where we are as a group. And the fact is that I would say, no, we're not all acting as sub-agents to the seller. What we're really doing here is we have to lean in on why buyer agency is important. And the fact that ultimately you have a contract with that buyer, they agree to pay you your compensation as it relates to that. They can ask as part of the offer for the seller to pay that compensation, but ultimately that's the agreement and how important representing the buyer is. And that's why your fee is what it is. That makes sense.
So the buyer's taking it right on the chin at the very first meeting that we have with them, acknowledging that they will pay 2%, 2.5% for your services unless somebody else pays it for them.
Well, they have the same in the same agreement, and now we're jumping ahead. Okay, and I
I just want to
probably
hear how
would-
it goes in practice, and if at that point that we have to have such a conversation, really I mean, I'm sure we could all explain the benefits of buyer agency. Because we've all seen people get taken advantage of, but who would sign up for that necessarily? And instead of just saying, hey, let's go on our own. It's a depressed market. We're buyers. We can do what we want. Why wouldn't they?
But hasn't that language always been in the buyer agency agreement anyways?
the language is
Yeah,
always,
everything's always been, we don't necessarily get paid, but we've also always had people saying very flagrantly that, hey, we are paying you. And now with that gone, what is the point? Or should we all just be listing agents? Which, I mean, that's fine with me if I could, get more listings or.
Isn't it true, though, that the obligation for our compensation always came, and it was always the buyer's responsibility to pay us, regardless if the seller was gonna contribute to it or not? It was,
Yeah, that line's always been there.
yeah,
it was always the case, and we modified right after the decision. You probably saw this in the January forms update, where we stressed that the buyer, the seller may or may not, offer any compensation as it relates to this. And what we've done in the buyer agency agreement, and now we're jumping ahead, so I'll probably turn to that, is yes, they agree to do that, but then they also agree that in their offer, that they're asking you, in representing them, to ask the seller to actually pay for your compensation. Does that make sense? So yes, they're saying that they're responsible, but they're also in control of saying, when we write offers, I want you to request the seller to pay that fee. Does that make sense?
It does.
Okay.
Thank you
All
for
right.
indulging me.
Oh, of course. No, it was all good. I'm just I'm gonna mention one thing. In paragraph 4, we modified the agreement term and the listing term because this is a Bright related. I know we're not gonna dive into Bright, but if you'll see on page 3, there's a provision in there regarding agreement term and listing term, because that's how it's defined ultimately in Bright. So we modify the forms as it relates to that. Okay, but I think we want me to get into buyer agency. So I will definitely jump into that right now, the exclusive right to represent the buyer. Just before I get into that, you're going to see in all of our agreements now a severability paragraph. And severability means that if any portion of our agreement has been determined to be invalid, it doesn't invalidate the entire agreement. GCAR has had this in their forms for a very long time. NDAR did not. So you're going to see this paragraph in the listing agreement, the buyer agency agreement, as well as the contract itself. So let's get into buyer agency. Compensation is defined in paragraph 8. And again, just like we have in the listing, we have the in bold up at the top, broker compensation is fully negotiable and is not fixed, controlled, recommended, or suggested by law or any multiple listing service or association of realtors. Just to make it very clear right there at the top. Buyer broker's compensation, buyer will pay broker blank percent, or it obviously could be a fee, broker compensation. If buyer enters into a contract to acquire real property, and then, kind of going through all of that. Then down below that, it says there's a checkbox. Buyer will request seller contribution to broker compensation in an amount of blank percent of gross sales price. So right in that same provision where the buyer agrees that they are legally responsible for it, they can ask right there for their offers that this is going to be something that is going to be offered for the seller to pay the commission. Okay, it's right there in the same thing. And so I know this is a different conversation than what we've had, because ultimately everybody's been thinking there's going to be a co-op commission, and therefore I don't really need to discuss this. But the simple fact is that the practice of buyer agency, and though I think we're light years ahead of many other parts of the country, we weren't really having a conversation about the fact that this is a contract. My brokerage and I represent you, and in that representation, you agree to pay us a fee, okay, as compensation for that representation. So now we're having that conversation, and then right below it, we're saying, you know what, if you want in your offers, we'll ask the seller to cover the costs.
Marty, can we zoom out for a second, just
Yeah.
for a second? And understand that there are two components, and talk about this and then elaborate, please. That there's essentially two components to the buyer agency agreement. There is the statutory obligations that are set in law that define what buyer agency is. But those statutory rules and laws do not talk about compensation at all. There's no mention about compensation in the statutory definition of what buyer agency is. It's solely describing the relationship between the buyer's agent and the buyer. Same thing goes with the listing broker, same concept. What the lawsuit did is it conflated and merged the compensation issue along with the buyer brokerage agreement and mushed it all together in the same topic. And I think that's the problem that a lot of agents are having, is that they're having trouble separating those two concepts. And while they are mushed together in this lawsuit, they are two separate, actual, distinct, different issues. We happen to put compensation in the buyer brokerage agreement because it's practical to do it that way. But they're two separate issues. Can you elaborate?
Yeah, I think it's important to, what makes you all different from other salespeople is that there's statutory provisions regarding representation. You're different. You have fiduciary duties to clients and things like that. Real estate is on another level than many other industries as it relates to sales, right? You're gonna find out information about your customers and clients that you have a duty not to share with other people. Confidentiality and things like that. Most other industries don't have that. You're so close, you border the line of being an attorney. I know, I don't know how many attorneys we have regarding this, but you're not there. You're not that, in that, thank you. You're not in that place, but you're really close to it as it relates to that. And therefore, there's statutory language regarding agency as it relates to that. And then you get to the whole idea of compensation as it relates to that too. And I think that this is an opportunity. And look, we've been working with you all for a very, very long time. Great agents are going to be able to demonstrate their value. And very quickly, you know, especially in the market that we're in, a buyer can then know and understand that they have a duty and obligation to pay you because you're going to be upfront and honest. And then you're going to be able to say, and as part of your offer, if you want to ask the seller to pay for it, by all means, that's completely negotiable. And I'll write the offer however you want me to write it. Because I'm going to show you every property that's out there, not every property that's out there, sorry. But you know, the one that's in the area of which you should be, what you're looking for that meets your needs and all the other things. So I think what we've done here is we've just made it very clear, right? As to what the duties and responsibilities are as it relates to that.
So you can leave that blank if they are not comfortable making this statement because they don't know what the competition will look like. They may not want to put themselves in the position of having to ask the seller to cover this, not knowing, you know, what the scenario is going to be like.
But, well, the difference also is this, because you can always amend your buyer agency form. You know, you can always amend that what they're agreeing to up here in the first part is, I'm obligated to pay you X% of the purchase price. And then in doing offers and things like that in competitive situations, if you want me to hear, we're having this initial conversation, and it's, when do you have this conversation? And I know that many people were signing buyer agency agreements right before they wrote the contract. Because a lot of buyers did not want to be saddled with that. I'm not going to get into the lawyer in me wants you to sign these as far out as close to that initial meeting that you have with people, but I'm not the judge and jury here.
Amen.
Okay, regarding that.
We want that.
Yeah, but what I'm just saying is that I think that this is an opportunity, having this conversation as early as possible, and then strategy is something else regarding getting a winning offer. And I think a winning offer is gonna be what nets the seller the most money for the most part, and is what the seller is looking for. Like if you want a rent back, or if you want this, and they want flexibility on this, and you as an agent are gonna work with the other agent to come to a deal that ultimately makes the most sense. All right, but this is a way, it should be easier for a buyer, at least if they're initially engaging you, say, oh, okay, so I'm actually now telling you that, yes, I know I'm responsible to pay for this, but in my offers, because I'm not gonna pay anything until we have a ratified contract, I didn't have that fully covered by the seller, or I can request it, and if we don't come to an agreement, then I'm not obligated to pay this commission. Does that make sense?
Why can't they just ask the listing broker, if I want to share, if you get paid that in listing brokers fee? Or instead of asking the seller to pay for it, why didn't we just ask the listing broker?
Because the listing broker, it's now compensation to the buyer broker is a function of the seller paying for it, not the listing broker making an offer for it. The co-op compensation idea of it is going away.
Yeah, there's no longer any enforcement of compensation exchanges between brokers.
Yeah.
It comes out the same way, I don't
It
care
does.
how you look at it.
It does, and you know, I had somebody saying the other day, this sounds like 6 1/2 dozen of another. And I think that is true. And I fully expect our industry, because how resilient we are, that that's what's gonna come out. But the difference is, and this is what I hope as an attorney, as an educator, as the person that comes out here and talks with you all about it, is I want people to understand, buyers and sellers, that they're getting under contracts, that you represent them, and that means something, and they agree to pay you X amount of dollars or a percentage of the sales price in order to do so. That, as long as that's what happens, and then we freely negotiate in the contract how that works, I think we're gonna be in the same place that we are now. It's just gonna be a different conversation to get there. Okay?
So are you saying to amend this, if you are writing a contract on something that states that they're providing a compensation of X, and it's different from this, would you at that point amend this contract with your buyers, your buyer agency, to reflect that as you're writing that up?
I probably wouldn't do that. What I would do is I would say, if my buyer really wants on every offer that they make for this to be paid, then just offer a higher price to cover the cost of commission. You know, essentially what you're doing is, if you remember, when it was more of a buyer market, or buyers don't have the money for closing costs, they build into the sales price the seller subsidy as it relates to that, to their closing costs. That's exactly what they're doing as far as the offer is concerned. Or if they're in a competitive situation, the price is going to escalate up. The payment of commission is going to be something as it relates to the ultimate net to the seller. I don't want to get too far out ahead of that, but I think I would not want to amend every single buyer agency agreement. I want there to be one in place. And then ultimately, if you find that you're not winning offers with this strategy, then maybe you make a modification as it relates to it. Or your client says, you know what, I'm willing to take more of that on, of the commission side of it, on in order to do it, and then you make an adjustment to the agreement.
And as a matter of administrative practice, Andrew's gonna, if we're going to be reducing our buyer agency compensation, that's stated in the buyer agency agreement, Andrew's probably going to want to be approving that. So, just keep that in mind.
So, and then we have paragraph 22, which deals with broker compensation. Hold on one second, let me just see if now I want to turn to the contract itself. Okay, the third document as it relates to it. So we have the residential sales contract, and we have price and financing, paragraph 2. And it's been modified, obviously. There's now a new paragraph, and it says, E is the paragraph, seller payment towards buyer brokers compensation. It's right underneath seller subsidy. Seller's nets reduced by blank percent or X amount of dollars as it relates to that. This obligation is enforceable by buyer's brokerage against seller and may be modified only by subsequent written agreement by buyer brokers agreement. So what we're doing there is, if you're representing a buyer, Remax distinct, if I'm just using that and representing the buyer, you're a third-party beneficiary as it relates to this contract, because it's now the compensation isn't between brokers. It's actually agreed to right here and enforceable through your buyer agency agreement. All right, but the compensation is going to be, the amount that the seller is paying is going to be right here on page 1 of the contract, on the sales contract.
And I think what's important as we represent sellers, and they're gonna be like, oh, I don't want to pay that. You've always been paying it. Those sales prices and all the comparables reflect you paying it. You know, this isn't, the lawsuit isn't a windfall for sellers to pocket 2.5 to 3%. It, like you said, it's just a shell game. It's just a different way to reroute the same compensation. And the same with the buyers. They can't be thinking, oh, now I have to pay you so much. Well, you always were. That $1 million purchase price includes my payment.
That's right.
And so I think it's just really important to get everybody to understand how the old regime worked, and that this is just a different way of talking about it. Otherwise, people are gonna try to cut our commission.
I completely agree. And I think it's not probably just in a way that conversation, a buyer is gonna have, the way that you speak to a buyer about compensation is just going to change a bit. And on the listing side, you're gonna be saying, well, I'm gonna bring as many people to you as possible. 99% of them are gonna be under buyer agency agreements, and you should expect that there is going to be a request. Even if you don't put it in here, that you agree to pay the buyer broker something, you should certainly expect offers are gonna come in requesting that you ultimately are gonna cover that expense.
Well, we could also not, we could choose not to work with sellers who don't offer buyer compensation also, right? We wouldn't be in violation of anything if that were the case, right?
Yeah, it's negotiable to the point where you are entitled to conduct your business the way that you need to. And if you
Which has always
are-
been the case.
Exactly, which, so if they're not willing to do if they're not willing to cooperate on the terms that you are willing to cooperate, then you don't have a mutual agreement, right, Marty?
That's right.
You know, so we're not forced to do business with everybody on every term that they present. Just because a buyer or a seller demands that I'm only going to pay this or that, and that doesn't meet your needs, then we have the ability to walk away from that if you know, before we get into the agreement. Now, once we've
Yeah,
got the agreement, that's a different
Listings are
story.
gonna get really expensive these days, and why should we waste our money and time if they're just wasting our money and time in return, you know?
We're going to be doing a better job paying our clients. I think that's
Hmm.
probably the result.
Yeah, well said. The next part, the next paragraph that is new, and for those of you that have the handout, it's on page 6 in the very middle. It says, broker's compensation, parties irrevocably instruct settlement agent to pay broker compensation at settlement as set forth in the parties' respective brokerage representation agreements. Just so it's in there. There was an irrevocably, we had to pay ultimately, but here we modified the wording as it relates to that, because we're now recognizing the fact that these are negotiated in those agreements themselves. All right.
So you need a copy of those agreements?
I won't. We talked about it as a group. Andrew and I talked about it at length. We're gonna wait to see what GCAR and MR and VAR, everybody does as it relates to that. But because compensation is negotiated, and because in Qualia, our system, it asks you all, it asks all you to put in your compensation, we can reasonably rely on that information as it relates to what we're going to be collecting at settlement.
So you might only ask for it if there's a dispute.
Exactly.
Yeah.
Yeah, and it'd be very simple, and I'm so glad that you mentioned that, because in this period of transition where Wright they're still offering co-op compensation, that's really important to maybe take a snapshot of it and things like that as it relates to it, as things are changing. Because if you close after August, 14th, and then you don't have, you can't rely on the co-op compensation in Bright, you have a snapshot at the time of the offer, ultimately what was being offered to you.
Yeah,
So I bring that up as.
that promise to pay in Bright, it goes away August 14th.
Yes.
There's no longer a promise from brokerage A to pay brokerage B anymore. That goes away.
Even on existing listings.
Well, the thing that look, you're not gonna have Bright as a resource to find out what was offered. So our recommendation is take that snapshot of it now so that you know that, yeah.
Start now, and I really recommend immediately start using the language and start using the terms in every single one of your contracts to state that the compensation that the seller is willing to pay for the buyer's broker's fee is going to be X. So make sure that that is stated in your contracts starting today.
Can we get a
Get
cheat
it?
sheet with some of your tips and such? And I don't mean to harp on the fact that I'm slow, but I'll probably be forgetting exactly the order of call as to what to do in all this. And do you have copies of, because I see you guys have a packet of information there. Will you have any sitting at the office that I could pick up sometime or online?
Well, as a matter of fact, we're working on putting that together right now.
Thank you
So-
so much.
What do we do about a listing in place that is gonna sit for a couple more months, right? And it's gonna become August 14th, and we still have a listing agreement in place till September 30th. Do we sit down with that buyer, with that lister, seller in August and say, we need to change the listing agreement?
I mean, you still have an enforceable agreement as relates to that. Dan, I don't know what your position would be regarding the change, since now some of the things that were agreed to aren't able to be offered.
Right.
It might be in.
I think, and I think to Kathy's point, that's why it becomes critically important. I don't think anything needs to change with your existing listing agreements. So if you've got a listing agreement right now that says that there's do we have anybody? That there's a watermelon to be paid to a buyer's brokerage. Let's say that that's what it is. There's a watermelon to be paid to a buyer's brokerage, then your watermelon will be paid to the buyer's brokerage. That's still part of your listing agreement. That's still part of the terms between the seller and the brokerage. That nothing changes with that. The only thing that does change is now, starting today, if you do get a contract, make sure that your new contract defines what that watermelon is.
Yeah.
Yeah,
Makes sense.
yeah. And that's the way to handle it. That's simply the way to handle it. Just make sure it's in the contract.
Do I have time just to focus on a few of the other
Please.
updates I think are gonna be important? Okay. We finished the 3 agreements, okay? Yay, all right. Couple things that I think are important. When we make changes, sometimes they're legislative, sometimes they're recommendations by all of you from a business perspective. And so some of these have been adjusted for those reasons. The first is the deposit paragraph. It's actually going to change that the earnest money deposit is now changed from days to business days. We had a lot of people that quick settlement timeframes, you ratify on Friday night, you got a 3-day weekend, and they can't get the deposit in the number of days. So business days is now a defined term. And that means it essentially is, it's in C in our definition section, means any day that is not a Saturday, Sunday, legal holiday, or day on which the state or federal government offices is closed, okay?
And to that point, how does the time of the day apply to the day?
The time of
As
day,
it's defined in the contract.
the time of day as it relates to, there's not a deadline as it relates to, like, nine PM or other contingencies. A day is a day. It's just a business day. It doesn't mean it ends at 5, and we're all in this business and I know we're all working well past 5, as it relates to that. So it's just the day and we had to put that, Commonwealth has a lot of state holidays. I mean, it's crazy because the courthouses are closed during those days. And you all oftentimes put settlement dates on those days and we can't record and things like that. So that's why we put that language in there. This was really just an ask from the association for that reason. The Virginia Resale Disclosure Act, that has been modified as well as it relates to the delivery, with condo docs, with HOA docs, or property association documents. And it will allow, because a buyer has the right to cancel, okay, they can waive it still in the Commonwealth. You could put in 0 days. If you leave this blank, these days in here for the right to cancel, it's gonna default to 3, okay? It's just gonna default to 3 as it relates to that. And I think it's important that it still is that whatever the seller delivers to the buyer, their right to cancel starts based on delivery. It doesn't matter if the seller gives all the things, we would like, the association to provide all the things, but Virginia, it's very clear that the buyer's right to cancel starts when they're delivered, whatever they're delivered, and that's it. There is a provision that requires the seller to deliver a resale certificate. Okay, and technically speaking, that resale certificate in D4 has provided one. We have found that associations, many of them are not completing them all the way, or not, because associations come in all different shapes and sizes. I think what we've done, I think, whatever you're delivered, that starts, but we're working to see on that resale certificate that every association is providing that information, because ultimately the statute says that a buyer, if they don't receive the resale cert, would have the right to void the contract as it relates to that.
So in a situation where a buyer feels that they didn't receive important information that they should have been entitled to, what is their recourse?
Their recourse is nothing. They need to void the contract.
Exactly.
Yeah.
And void, that's the alternative, is void.
Can we extend the review period till they get us like the updated minutes?
Of course.
And we can extend it as long as both parties agree?
Extension only allows for up to 7 days by the statute. So you can go from 3 all the way up to 7 through a written agreement of the parties.
But if you ask for an extension as the buyer's agent and you present it to the listing agent and they don't respond by your deadline, what happens then? You've lost your
opportunity. You're still at your 3 days.
Right, exactly. So just because you've asked for an extension, that means nothing in terms of the enforceability of the contract. Your contingency still dies if they haven't already agreed to it. And I think a lot of us miss that piece of it sometimes.
Yeah, you got to get the agreed upon extension in writing, or your client should just exercise their right.
Because just because you ask for it doesn't mean you're going to get it, and if you don't get it, you've got to void it.
So we can put 0 days in here, essentially not giving them an out.
You can, because the buyer has they can waive their right to cancel if they want.
They can.
They can, and
So that is totally new, because I thought that was not.
it actually isn't new. It happened probably 2 legislative sessions ago, and we have thought that the legislature would right that wrong, and they haven't. They stuck with it, that the buyer still has the right to waive their right to cancel. I think, I'm gonna give you my personal professional opinion. I think that stinks. I think nowadays with associations, especially condos, the requirements for reserves and things like that are astronomical. And as it relates to that, buyers waiving their right to cancel, I would treat it like a pre-inspection contingency. You gotta try to ascertain as much information as possible before ratification if your buyer needs to be competitive in order to waive their right to cancel, because they're buying into something they have no idea. It's like a business. It's a group of people that they're in, and they have no idea what the financial responsibility might be. And I had a situation that I dealt with just this past week where great buyer agent, hence their value, was able to get the information prior to ratification, got the minutes as it relates to it, and there was a $35,000 assessment that was being made due to reserves for repairs and things like that. Had she not gone to that extent in order to provide that, the buyer would have been settled with,
So that was coming though.
That was
If it's
coming.
Already,
yeah, it was.
they have to disclose that if it's already.
If it's already done, it will be disclosed in the forms, but if it's even disclosed and they haven't looked at it yet, and they're waiving the right to cancel, what's that gonna do to them? You know, as it relates to that. So I'm giving you that as a little background. I don't want to go into too much detail regarding that. Last few things, the escalation addendum is being modified as it relates to seller concessions and payment toward buyer broker compensation, so that we understand what the net would be. Right, because that first page of the contract's changing. The contingency and clauses addendum is no longer going to have paragraph 2C, unrepresented seller or builder and buyer's broker. It was removed because it's no longer necessary. We're dealing with compensation payments on the first page of the contract, so it's not necessary.
And we already have a form.
Yes, that's right. And then last but not least, the broker representation agreement amendment, that we've now modified that to also reflect agreement term and listing term. So you would amend the document through that form, not, crossing out and changing the agency agreement itself. There were a number of changes regarding leases and things like that. I have all of those things in the handout. Peruse those and look at them. And last but not least, the airport impact overlay district disclosure notice has been removed because Loudoun County is not in the Virginia legislature. A county cannot enforce a disclosure. It needs to be on the state level. So they weren't in their rights to actually provide this disclosure. So essentially it was removed.
Oh, really? So we no longer are required to.
Effective July 1st is when that goes into effect. So you still need to do it as of July 1st. It prohibits a locality from establishing or enforcing a mandatory disclosure requirement for a real estate licensee.
Okay. So keep that in mind. If you're in that footprint until July 1st, we're still gonna require.
And the last thing that I would just say in closing, I know this was a lot. Look, Mel is she's distraught over there in the upper left.
Her head is blowing up.
Sorry, I'm picking on you, Mel. You're one of the few faces that's live on the screen. This is what I would say, all right, regarding this. And I know this is a sea change in having this conversation. But the reason why people deal with us, okay, you as real estate professionals, myself as a title professional, mortgage bankers, it's because we know what we're doing. We're great, we're responsive, and we give above and beyond service. Okay, I mean, we sell our company as being the best legal resource in the DMV. And we need to be on it all the time in order to do that. I thought I saw Louise up there. I'm dealing with a case with Louise and I mean, we're dealing with an easement agreement and all this stuff. We're dealing with land use attorneys and all these different things. And I mean, we have the ability to do that on that level. We can deal with all the things of what everybody wants and that. So sometimes you're going to get layoffs. But most of the time, the reason why people deal with you is because A, they know you, they trust you, and you're going to work really hard for them. And that's what all of this is about. I think everybody in this industry is now just in a position where they have to demonstrate that value. And as it relates to communicating that with your clients, whether it's on the listing side, whether it's on the buyer side, we're going to, especially in this market, yes, there's going to be some people that are going to say, well, this is a way for me to save money, okay? But we've seen the Redfins try to do that. We've seen lots of other people try to basically diminish value. And what have we found? They're not profitable. And they're not winning. And so I think this industry has always been about trust, hard work, and everything else. And the fact that I'm gonna not get paid until we're successful, which is pretty amazing. It's a huge risk that all of you take in order to do it. I guess all of us take that risk together as it relates to it. And just, I would just follow that through. I think this change is gonna be a period of change. And then as soon as that's over, maybe there's gonna be anxiety as it relates to it, just like when the court decision came out and NAR's this, and there's all these different things. I think eventually it'll come out the other side and we'll all be better.
Yeah, I really think to piggyback on that, I think what we're hearing a lot of doom and gloom about this, the results of the lawsuit, right? And like every other conflict we've ever had in our industry, we've always come out of it and we've adapted and we've made it work. And yes, some of the components of the doom and gloomers will come to pass and they will be part of the way we do business. But for the most part, I think this is just a speed bump along the path towards getting us to our goal. And there will be some changes, but I think it's going to be modest and it's going to be, we're going to adjust and adapt. And I don't subscribe to the doom and gloomers. There's a lot of doom and gloomers out there who say that this is this is going to be the end of everything. It's a speed bump along the way. So don't be discouraged with it. We just have to adapt and grow.
That's right. Just want to thank you all for giving us an opportunity to go over this with you. Love working with all of you, and let's just rock and roll this summer together. Okay? So thank you.
Thank you. You'll go over
Thank
with us
you.
again if we need it, right?
Say that again, Derek.
You'll go over it again for us if we need it, right?
Absolutely. Sure.
Thank you
And this
so
is-
much.
We've got the majority of this session was recorded. We forgot the first part of it. I caught it just shortly into Marty's speaking, but there's that. Any other questions from anybody? Or anybody have any buyer seller needs they want to share? Or questions overall?
Well, I have one question going back to Bright and more to what Kathy was saying. Those listings that we have active in the MLS prior to August 14th, when that commission field just disappears, what do we put in, and we go into Bright because we got to do something. So now we're going to put a comment in the concessions field?
No. So, for now, if you're going to write a contract on that, on 123 Main Street, print that screen for that MLS and save that compensation amount and keep it in your records. Okay, that's issue number one. And then as you're writing that contract, you're going to state the price, state that compensation that you're expecting to get in your contract, and that should.
I'm talking about a listing. So that field, a listing that's already active before August 14th.
Right.
With a compensation field. That field is going to disappear. There's going to be nothing there. So
Right.
then we go in and make a comment in the concessions field that says seller is willing to make a concession. To the bottom.
Of an overall concession amount, yes,
Right.
correct. And you can break it down into various different categories. The only category that is not going to be there is how much the seller is willing to pay for the buyer broker compensation. That's the only one that's not going to be part of it.
Has that changed since May 30th, since they put out that?
That'll be effective April 14th. Not sure what your question.
So, correct me if I'm wrong, but I thought Wright came out with the concession that then broke down how that concession would be used. And one of the options was to pay the buyer broker.
Right, and that's gonna be gone.
It is, they just came out with it.
It's gonna be gone.
Oh,
Okay.
no. What you're saying, that field is going to be there, but only in the closing status. In the
Correct.
active status, the concessions field will be there, but that particular one about it being to pay the buyer broker will not be there until you go to close it.
Until you close, it'll clarify where that.
Yeah, once you close, once you
Okay,
close you've got the listing, and once you close it out in Bright MLS.
yeah,
Now it'll populate that field, and you'll be able to say,
So-
the seller paid the buyer broker X, whatever.
okay,
And you'll be able to fill it out. That's the
Okay.
only time it'll appear. Yeah.
okay.
With our listing agreements that we're gonna be taking between now and August 14th, we're gonna do it the old way. Is somebody gonna give us a warning on August 13th, change all your MLSs, or is it automatically gonna?
It's, no, Bright MLS is going to automatically remove those fields. So it's just gonna be an automatic removal. You don't have to do anything. You just need to know that it's going to be gone. At midnight, on August 13th, it's going to be gone.
I have a question. In
Yes,
regards to taking a listing between now and August the 14th, can we go ahead and use the latest forms versus the old forms?
Yes,
Yeah.
Use the July 1 form.
yes.
After July 1 though.
So where do we get, are those forms available in zip or where are they?
So, well, they will be available in zip forms and in SkySlope forms as of July 1st. So NVAR, GCAR, Maryland Realtor, all of them have issued those new forms. And they will be effective on the effective date that that association says. So for NVAR, it's July 1st. So if you take a listing between now and July 1st, you're going to use the forms that exist today. You're going to take the listing after July 1st, you're going to use the July 1st forms that are going to be populated and will be changed in zip forms and SkySlope forms.
Okay,
And if
so July 1st. So if I take a listing tomorrow, it has to be on the old forms. There's no exception. I can't just jump ahead and get the new forms.
You're not going to have access to the forms yet.
Right, that's what
So-
I heard you say, right? Because I saw them in NVAR in their library, but I didn't see them anywhere else.
Right. I mean, you can use it. Certainly you can use the new forms.
Dan,
If they're published by NVAR right now, then you can use them, yes.
they're watermarked as educational version.
Exactly. If you don't use the watermark versions, and I think that's probably what's on the NVAR site is a watermark version.
Mhm.
Understood. Thank you.
Okay. Any other questions?
Well, if we're gonna extend, we have a listing that's just not selling. At some point, we're gonna have to extend that agreement. If it goes through August 30th, do you recommend we just have a whole new listing agreement on the July 1 form, or try to extend it?
Not just extend it. You could do it, but I don't see a reason to do it.
List it for 3-4 years, then you don't have to get them until, if you do it now before August 1st.
Yeah, you could do it either way, but I don't see a reason to have to do that if you don't want. Any other questions? Buyer seller needs?
Well, let me ask you about the Bright training, because I signed up for one and had to miss it. Is that easy to do on Bright?
Yeah, just go ahead in the link. I posted it on Facebook in the Facebook group. Click on that link and it'll give you the next one. They're having like 4 or 5 of them a day. So you can just click on the link and you take the course. But pay attention to the form. The form that is discussed, that's added, that's a new form, is critically important that you all understand that every single buyer and every single seller needs to get that form. So that's a new document that's going to be required to be added into the checklist that you need to have signed with your buyer agency agreement. Okay, and when you submit it, you're gonna need to have it. It is property specific. It has name specific. At the top of the page, I didn't bring a copy of it with me, but at the top of the page, if you want a link to it, the form is in Bright right now. But at the top of the page, there's a space for your agent name, the client's name, whether they're a buyer or a seller. And what I'd like you to do is to have them put a signature on that. Put a signature for yourself, put a signature for your client, indicate whether they're a buyer or seller. And then there's also a field that says property. And it's important that whatever your contract property is, that form have that property address on that document.
So it has to be updated. So you're saying you want it signed with a buyer broker, but then if it's property specific, do they
You would
re-sign it?
just add the property, just add the property address on.
When you do the contract, add that word?
Yes.
Okay.
Yeah. I mean, yeah. Now, this is part of the lawsuit requirements. So, if you don't comply, keep in mind that that Bright is imposing a $1,000 fine for not doing that. And that's why I'm pushing that as an important thing to note, because ultimately it'll come down on the agent. And they're gonna fine the agent for not doing that. Now, Bright is not doing it because they want to collect fines, contrary to popular belief. They're doing it because the lawsuit mandated that they do it. And so that's part of where we are. And so that's where it applies. Now, I don't want to see us get fined, and so that's why I'm kind of pushing that up front to make sure that you're aware.
And you sent us a copy of that, or is it already on?
It's on right in the policy tab on the upper right-hand corner. You go policy, and then it'll scroll, and then you scroll down and there's a forms highlight. And then under the forms, it's the first form under the forms list.
Policies.
Policy, then scroll down to forms. Policy,
Rules.
what does it say? Bright MLS rules, policy, Bright MLS rules, and then in the Bright MLS rules, there's a forms, and it's the first form listed under forms.
And that's effective when now, or?
That's effective now.
Really?
Yeah. Yes, that one right there. So the two forms are this form that I'm talking about and the office exclusive form. So if you're looking for the office exclusive, that's also there too. Keep in mind, coming soon, coming soon days goes away. There's no longer going to be a 21-day limit on coming soon. So you can put indefinitely coming soon if you want to. That goes away. So that should eliminate the need to do a lot of temporary office exclusive listing, because we always have, remember, keep in mind, we need from the effective date of the listing agreement, we need to have every single listing uploaded, the data for it uploaded into Bright MLS within 2 business days. And so that's satisfying. So you have to put it into either an office exclusive status or one of the active statuses.
The 21 days is going away.
21 days is going away.
Like, okay. So you can put it in coming soon indefinitely,
Yes. Yeah,
but the same rules apply, no showing.
correct. No showings, correct. Exactly. If it's in a coming soon status, you can't show it.
I thought you
Dan.
said they're taking
No,
They're taking away the limit.
they're taking away the
21
day limit
the 2 weeks or whatever.
for 3 weeks.
Yeah.
Yeah,
Dan, the form that you said that needs to be done right away is the MLS disclosure and residential seller landlord options.
yes,
Yes.
So it only is to do with residential properties.
yes, yes, that's correct. This discussion all is about residential properties, not commercial.
So this. is
Okay, even
after-
though it's on Bright,
Even though it's not right.
even though the commercial property's on Bright.
Yeah, that does not apply. This is only a result of the lawsuit, of the class
Okay.
action lawsuit. Class action lawsuit only has to do with residential properties.
Thank you.
So if I have a rental with you right now, I should have this form.
Correct. Yeah.
Thank you, Dan. Bye.
All right. Pleasure. Have a great day, everybody. Otherwise, I can stick around and for more Q&A.
Thank you.
You bet.